There is a dangerous idea spreading in our society that if you hold elected office, the rules don't apply to you. That there's one set of laws for everyday citizens and another set for those in power. And when the people entrusted to uphold the law begin ignoring it, bending it, or interfering with elections, the damage doesn't stop at one race or one county. It destroys trust in the entire system. The rule of law only works if everyone follows it, especially judges. Judges don't get to decide when election laws apply. They don't get special shortcuts. And they certainly don't get to pressure election officials or rewrite the process when they don't like the outcome. Yet, that is exactly what appears to have happened here. On November 10th, 2025, Judge Joel Hell had no problem filing his own application for re-election with the proper filing authority, the county party chair. But on December 8th, 2025, Judge Hell submitted a candidate's application for county party chair to the wrong authority, the elections administrator. That matters because Texas Election Code Section 172.022 is crystal clear. Candidate applications must be filed with the current county party chair or the secretary of the county executive committee. The elections administrator is not a lawful filing authority for party specific applications. Submitting to the wrong authority can invalidate the filing. Before we go any further, we need to ask a basic question. Why is the county judge involved in a party chair application at all? A county judge has no role in receiving party chair applications, holding applications, coordinating filings, or acting as a middleman for a candidate. That responsibility belongs solely to the candidate and the proper filing authority under Texas law. The filing period for all elected offices ran from November 8th, 2025 through December 8th, 2025. The candidate could have submitted their application at any time during that 30-day window. There is no legal reason for a sitting county judge to be personally involved. Yet, on 12/5/2025, Judge Hell left a voicemail for the elections administrator obtained through open records request saying,
Shannon, I've got somebody that's come in and wants to file some stuff. They're not going to be in town Monday. I'm having them fill it out, and I'm going to hold it till Monday and get it to you. Call me back if there's anything I need to know. Bye-bye.
That decision, not turning it in before the Monday deadline, created a real risk that the application would be incomplete or invalid, and that's exactly what happened. By the time the application was turned in on December 8th, it was submitted to the wrong filing authority and was missing the required precinct chair petition, which was clearly stated on page 2 of the application itself. Texas Election Code 172.021F allows county parties to require that an application for county chair be accompanied by a nominating petition signed by at least 10% of incumbent precinct chairs. That requirement was printed clearly on page 2 of the application itself. Anyone who had attended meetings, anyone who had done basic due diligence, and anyone familiar with party rules would have known this. The application was incomplete because the required petition was not attached. At 10:19 a.m. on December 8th, after Judge Hell submitted the incomplete application, he texted the elections administrator. Has that been taken care of yet? She replied, not yet. He responded, what's the holdup? Once it became clear the application was defective, Judge Hell went around downtown telling people, I refuse to accept the filing. That is false. The application was received from the elections administrator, but rejected because it was incomplete as per Texas election law requires. At 3:38 p.m. that same day, Judge Hell escalated the situation by making false public allegations when he sent an email from his county email account, copying a U.S. congressman, a state senator, and over 130 county employees, accusing the Rusk County Republican Party of illegally blocking candidates and claiming precinct chairs were afraid to sign petitions due to retaliation from me. First, requiring signatures is not retaliation, it is state law. And second, this claim does not hold up. After those accusations were made, all 16 precinct chairs once again unanimously signed a second nominating petition for me. unanimously. And it's especially telling because those same precinct chairs had the opportunity to sign for someone else, which would have kept me off the ballot entirely. People who fear retaliation do not behave that way. But the interference didn't stop there. Judge Hell met with the elections administrator and directed her to place the county auditor and the county clerk on the early voting ballot board and directed her to make it happen. That is not within his authority. Primary elections are administered by political parties, not the county. On January 7th, 2026, at 10:18 a.m., the elections administrator explained in an email to the county auditor and the county clerk that the election judges and workers are appointed by county party chairs, which, by the way, are the same election workers the county has used for years. Individuals holding public office may not serve on the EVBB. Poll watchers must be registered voters in the county, which would eliminate the county auditor, and may not hold elective office. Using paid county employees creates ethical and legal concerns. She also stated she was surprised Judge Hell would insist on actions that are contrary to law, and given how closely Rachel Hell scrutinizes governmental matters, such a violation would almost certainly be brought to public attention. At 10:24, it appears the county auditor forwarded the email from the EA to Judge Hell. At 10:29, Judge Hell emails the EA that the county clerk reminded him she is on the ballot and M. McCauley will use one of his girls instead. In that same email, Judge Hell requested that the EA come before the Commissioner's Court on February 10th to explain the ballot counting process for all ballots. This request is notable. Judge Hell has served as county judge since 2011. By 2026, he has presided over numerous elections, canvasses, and certification processes. When a judge repeatedly questions established election procedures without evidence, while simultaneously attempting to influence who administers those procedures, it raises serious concerns about appearance of impropriety and interference, both of which are prohibited under Canons 2 and 3 of the Texas Judicial Code of Conduct. Despite being told multiple times that the county has no authority to appoint EVBB members in a primary election, Judge Hell continued pushing names forward. In an email at 2:16, he says Karina or Amy from the auditor's office are going to do it. On January 8th, 2026, at 9:31 a.m., the elections administrator responded to Judge Hell. She reiterated clearly and unequivocally that election judges and election workers in a primary election are appointed by the county party chairs, not the county. County party chairs were required to submit their appointment list by July 2025, as mandated by Texas election law. Only the county party chairs are authorized to add or remove names from those appointment lists. She further explained that if the question was whether M. McCauley, Amy, or Karina wished to serve as poll watchers, that was an entirely separate matter. Poll watchers are unpaid, may only observe, must complete the Secretary of State required training, and must be appointed by a candidate, not by the county. The EA then raised serious ethical concerns. She warned that using county employees paid with taxpayer dollars to perform election related duties could create the appearance of impropriety or conflict of interest. That warning came from someone with 18 years of experience as an elections administrator, including 5 years in Rusk County, and prior service as an election clerk before becoming an EA. She also referenced a prior conversation in which Judge Hill stated that neither he nor the commissioners trusted her. In her words, that statement was deeply concerning. She said she was truly baffled by the level of distrust, unaware of any specific issue or perceived problem, and is unable to determine what the court was actually trying to resolve. She further stated that in her entire career, both in Rusk County and elsewhere, no one had ever questioned the integrity of the election process or expressed this level of concern regarding the elections of the county parties. When an experienced elections administrator repeatedly explains the law, raises ethical red flags, and asks for clarification, and a sitting county judge continues to push anyway, that is not oversight, that is interference. Judges are held to a higher standard for a reason. Canon 1 requires judges to uphold the integrity and independence of the judiciary. Canon 2 requires them to avoid impropriety or the appearance of impropriety. Canon 3 requires them to perform duties impartially and without interference. Canon 5 restricts political conduct that undermines public confidence. When a judge repeatedly disregards election law, pressures election officials, misrepresents facts publicly, and attempts to influence the administration of an election, we have to ask, is this a violation of Texas Judicial Code of Conduct? And more importantly, if judges believe they are above the law, what happens to everyone else? Because a two-tiered system of justice doesn't just hurt one election, it destroys the rule of law itself.